Today, we're going to talk about conflicts of interest and prospective clients and steps that lawyers can take during the intake process to protect their clients and their firms from allegations of conflicts of interest during the course of a representation. I'm Christy Lewis Abate.
And I'm Chris Stigmeyer, Director of Risk Management for the Bar Plan Mutual Insurance Company, with your Risk Management Minute. One of the things that we are always concerned about is how well lawyers go about, and certainly from an underwriting perspective, establishing and utilizing an appropriate conflicts of interest checking system for the law firm. Uh, Conflicts of interest are an important consideration for law firms because they can supercharge an otherwise defensible malpractice claim into something that becomes a very hot issue and creates a lot of potential division in how a claim can be defended in certain circumstances. There is a common misconception, I think, with a lot of insureds that we deal with, that because of the kind of practice they have, the kind of clients they take, and so forth, that conflicts of interest just aren't an issue for them. What we can tell you, viewer, listener, is that they're always an issue for every lawyer. And the problem for a lawyer who says, well, because of the kind of client I take, I can't have a conflict of interest, or the kind of law that I practice and I can't have a conflict of interest, is that it limits these relationships that you're creating with your conflicts to only what you're doing today. 3 years from now, 5 years from now, 10 years from now, I think the longest out I've seen is 12 years where a lawyer was disqualified from a representation based on a prior representation that they had with what became the adverse party in a matter. 12 years later, it's important to be checking these things as you go throughout your career. There's a very interesting ABA opinion that addresses this kind of client intake process. It is opinion 510510 from March of 2024. And it takes the approach of how I recommend. I mean, it's not like they were listening to Chris when they wrote the opinion, but how lawyers ought to start to approach their client intake process from the perspective of using the rules to protect themselves from disqualification immediately, or potential disqualification in the future from representations. And it's kind of a stepped approach. That is, the information that a law firm receives as it goes through the prospective client determination is stepped through so that there's limited information initially, usually something along the lines of who's going to be the adverse party. You take a law firm takes that basic information, runs a conflicts check on that only because that's all the law firm has, and then makes an immediate determination: would we have a conflict of interest because we've represented this entity or this individual in the past? And then from there, if that comes out clean, then additional information is going to be delved into as this consideration for even taking on the client. Remember, this is still the prospective client stage. Will have to be accepted by the law firm, and every bit of new information that the law firm accepts broadens its opportunities for being disqualified at some future point, just from the very receipt of the information alone. It doesn't require anything more than that potentially. So that's why it's so necessary for law firms to understand how these rules come into play, how imputation of one lawyer's conflicts at a law firm can disqualify the entire law firm. And then specifically in Missouri, a critical part of this application and understanding of this process is the rules in Missouri do not permit screening. They don't provide for screening of the affected lawyer as a way to avoid a conflict or a disqualification from a representation by the other members of the firm. And that's I can't say it's unique just to Missouri. I think some other states don't have that. But the ABA model rule and many other states' imputation rules do provide for that screening procedure, but Missouri does not. And so that then becomes a very important issue to consider through the conflicts of interest process. And one of the things that law firms also then uh, routinely fail to do is to take in enough information to populate their conflict of interest uh, database, essentially, to run against as information is gleaned from a representation. And then the other place that law firms have a historically difficult time or issue understanding is that every change in the representation warrants a new conflict of interest check. If a party is added to a case, if a new attorney is added to a case, if a judge if there's a change from one judge to another judge, every one of these events warrants then the new conflict of interest check. And so oftentimes what we see is that lawyers will confine their checking to this very basic kind of, well, I've never represented the opposing party, so there's no conflict of interest. Well, that's a good place to start. It isn't then the place to end the conflicts of interest checking process. And so if you, viewer, listener, will stay with us, coming in the near future, we are going to have additional information about what law firms can do to effectively protect themselves from this very pernicious kind of potential malpractice or ethics violation accusation.
Thanks, Chris. That was really helpful information. If you have additional questions about conflicts of interest, please feel free to reach out to Chris at the Bar Plan, www.thebarplan.com, and there is a link to his email address there. Thank you for your time today. I'm Christy Lewis Abate,
I'm Chris Stigemeyer.
and this is your Risk Management Minute.